Estate planning is often thought of as something only for the sick and elderly. However, nothing can be further from the truth. So today, we're going to be talking about when you should consider doing some estate planning of your own. Hi, I'm Andrew Bethel, and typically, the first question that I receive when someone finds out that I'm an estate planning attorney is when they should be setting up their estate plan. Usually, I'll ask them if they have a house or any kids and use those answers in order to guide the conversation from there. But I think sharing my underlying thought process may be more helpful if you were wondering when you should worry about estate planning, which is something I expect to be the case, otherwise you wouldn't have clicked on this video. As a quick preface, planning one's estate can mean many things or creating multiple documents at the end of the day. However, to keep matters simple, today I'll be focusing around 4 main estate planning documents of your estate plan. First is the revocable living trust, next is your last will and testament, and finally your healthcare and financial powers of attorney, which are 2 documents on their own. With that, there are 3 factors to consider when determining whether you should begin planning your estate. The first one is planning for care now. Next is planning for care later for yourself and or loved ones. And then third is planning for the disposition of your estate. Let's talk about that first category, planning for care now. Even if you have nothing, by which I mean real estate, children, or significant assets, that doesn't mean you don't or won't need help should you be unable to help yourself. This is where documents like powers of attorney come into play. For example, you can't predict when unexpected medical events will occur, such as a car accident. If you're not in a position to manage your health or finances because you're stuck at a hospital or in a coma, then you are going to need someone that you designate to work on your behalf. Under a financial power of attorney, that is your attorney in fact, and under your healthcare power of attorney or advanced healthcare directive, that is your agent. Not having a financial power of attorney in place means a bank is not going to let someone else manage your finances, pay bills, or even access bank statements to begin with. Additionally, not having a healthcare power of attorney or, again, advanced healthcare directive, that may lead to your family fighting over what to do and medical staff unable to act or just leaving them to do the bare minimum. Many of you might remember Terry Schiavo. In that case, Terry had nothing in writing when she collapsed, and although she was ultimately revived, she persisted in a vegetative state she never recovered from. The entire matter, which consisted of 14 court cases, involvement from the Florida governor, Congress, and even the President of the United States, and national media attention, all this rested on the husband's claim of an oral statement from Terry that she did not want artificial life support if there was no hope of recovery, versus her parents' desire to keep their daughter alive as they still had hope for recovery. Just because you don't think you have enough assets to manage doesn't mean you won't need someone else's help when the time comes. It is best to have the pieces in place now rather than wish you had later. Next, we have planning for care later or in the future. This can be broken down into 2 subcategories, family planning and long-term care planning. This is where children and the elderly come into consideration. If you have or expect to have children, then part of your parental duty is to plan for the care of that child in the event you and your partner aren't around to provide for them. In your last will and testament, or a separate document called a nomination of minor guardians, you can nominate who you wish to be the caretaker of your child, the guardian. You can even specify a guardian for the finances and a guardian for their care. This is typically done in conjunction with a living trust wherein you set aside money to be used for your child's care so that it is legally obligated to be used for their benefit and will avoid probate on your passing, allowing for more of your estate to be preserved by avoiding huge legal fees and lengthy time delays. Just like the powers of attorney, having nothing in writing means you have no input on who is to become the guardian of your child, and you're leaving it up to family and the courts to essentially fight it out. Having your wishes known in writing will carry great weight with the court, who is going to be the final arbiter of what is in the best interest of your child. Again, not something you want to leave open-ended or up to chance. The other aspect of care for later I mentioned is long-term care planning. If you or a loved one needs to go into an assisted living facility, a nursing home, or be on hospice, then unless you or they do the proper planning and preparation ahead of time, their assets can be wiped out as the cost of long-term care is extensive. It could be upwards of $10,000 a month, depending on what care is required. Plus, if you're on a program such as Medi-Cal, but you didn't properly plan ahead of time, then your house may be subject to what's called a Medi-Cal recovery claim. Essentially, it's the state, the government, coming to collect against the value of your home for the cost of your care. Not properly planning for long-term care concerns could mean depleting your estate now or ending up with the government coming in and trying to collect after you pass away. As a quick note, there is a video on this channel where attorney Dale Bethel discusses Medi-Cal and the qualification process in great detail. It is a year old, but at this point, it's still extremely relevant and illuminating. We do plan on posting an updated presentation soon, so subscribe and click the bell to be notified when that's released. Alternatively, you can subscribe to our monthly newsletter. Finally, we have the category of planning for the disposition of your estate after your passing. In layman's terms, who gets your stuff and how much are they going to get? This is where the revocable living trust shines. If you have children, if you have real estate, regardless of the value, or if you have cash, securities, or other collectibles that in total are over the probate threshold for your estate, then you need to plan your estate and you need to create a living trust. I've already spoken at length about children and planning for their care, so I'll briefly go over the other two that I just mentioned. Real estate, regardless of the value, is going to trigger some involvement of the probate court no matter what. In California, there are basically two routes that can be taken in order to administer real estate depending on the value, but both mean court involvement. The shortened process is only for real property below approximately $61,000 as of April 1st, 2022, which in California is really an empty lot out in the desert. Any real estate above that value, we need to go through the normal probate process, something we've talked extensively about on this channel on why you should avoid like the plague. However, even if there is no real estate subject to probate, your estate may still have to go through probate if, when adding everything together, it totals over $184,500. Again, as of April 1st, 2022. If everything is above that value, then probate court involvement is required. This number will vary by state, but unless you live in California, then you should assume your state's probate threshold is lower, meaning less money is needed in order to trigger a probate of your estate. Estate planning through a revocable living trust means you control where your assets go for whose care it's to be used, and allows for your estate to avoid probate, thus preserving more of it to go where you want it to go. To summarize, since I covered a lot, you should begin planning your estate, number one, right away, utilizing powers of attorney at the very least, since you cannot predict disaster. Number two, when there are children in the picture, or long-term care or elderly care appears to be on the horizon. And finally, number three, when you have assets that may trigger a probate. Any real estate, regardless of the value, or significant value in other assets, or at least what your state considers as significant. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here. But don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.